What's going on? YouTube, listen up. Young Elder Gang. This is Ted Strokes at you with another banger. Please make sure you like, subscribe, and share this video, fam. I hope this video get at least 100,000 likes in this video. You will find history definitions, scripture information, and best of all, what we Americans have been deprived of from the beginning. The truth, keep in mind, this content used in this video is intended for entertainment, educational and informational purposes only, and is not a substitute for legal advice. It is recommended to consult with a qualified attorney regarding any legal issue. We will give you the total truth as we best understand it today. Be sure to hit that like button, Young Elder Gang, hit that subscribe button if you're new to the channel, hit that bell, and don't forget to check back with us every day for new content. Literally, to grow to, as the interest accrues on the principal. Accruing costs are those which become due and are created after judgment of an execution. 2. To accrue means also to arise, to happen, to come to pass. As the statute of limitations do not commence running until the cause of action has accrued. 1 Bouv Asturias 861, 2 Rawl 277, 10 Watts 363, Bactir ABR. Limitation of actions D1, Bouvier 1856, 6th ed. In law, to accrue means to come into existence as a legal right or obligation, such as the right to sue or the accumulation of interest and penalties. A legal claim accrues when a cause of action is complete and legally enforceable, which is crucial for determining when statutes of limitations begin to run. It can also mean to build up over time, as with interest on a debt or expenses incurred but not yet paid. Key legal definitions of accrue. As a legal claim, a cause of action accrues at the moment it becomes a complete and present right to sue. Example: a right to sue for breach of contract doesn't accrue until the contract is actually breached, not just when a party suspects it might be. As an accumulation over time, something that grows or is added to over a period. Example: interest on a loan or penalties on an unpaid tax bill accrue until the debt is paid in full. In accounting and finance, it refers to an expense that has been incurred but not yet paid, or income that has been earned but not yet received. Example: a company incurs an electricity expense in December but doesn't pay the bill until January. The expense accrues in December. Why accrual is important. Statutes of limitations. The moment a claim accrues is the trigger for the time period during which a lawsuit must be filed. Legal rights. Understanding when a right accrues is fundamental to knowing when you can legally take action. Financial and tax obligations. Accruals are essential for accurately tracking liabilities, which can affect a company's financial statements and a taxpayer's financial obligations. A formal charge against a person, to the effect that he is guilty of a punishable offense, laid before a court or magistrate having jurisdiction to inquire into the alleged crime. Black's 6th. In law, an accusation can refer to a formal charge of wrongdoing by a legal authority or a less formal claim that can initiate legal proceedings. It is important to distinguish an accusation from a conviction, as an accused person is presumed innocent until proven guilty. Formal legal accusations. In the context of criminal law, a formal accusation is the start of the legal process. It can take several forms, depending on the severity of the alleged crime. Indictment. For serious crimes, felonies, a grand jury may issue a formal accusation in a document called an indictment. This means the grand jury has found sufficient probable cause, based on the prosecutor's evidence, to charge a person with a crime. Information or complaint. For less serious crimes, misdemeanors, a prosecutor can file an accusation directly with the court, which is known as an information or criminal complaint. This does not require a grand jury. Charging document. In the most general terms, a formal accusation is a charging document that asserts that a person has committed a crime. The Sixth Amendment to the U.S. Constitution guarantees the accused the right to be informed of the nature and cause of the accusation. Informal and non-criminal accusations. An accusation can also be an informal claim of wrongdoing that triggers a legal or institutional response. Civil lawsuits. In civil court, an accusation can take the form of a formal claim in a lawsuit, such as when one individual accuses another of negligence or breach of contract. Workplace complaints. An employee might make an internal accusation against a colleague for harassment or discrimination, which could lead to an internal investigation. Defamation. If a false accusation is made publicly and damages a person's reputation, it can become the basis for a civil lawsuit for defamation. Spoken defamation is called slander, and written defamation is called libel. False accusations and their consequences. A false accusation is a claim of wrongdoing that is not based on fact. Making a false accusation has significant consequences for both the falsely accused and the accuser. Consequences for the falsely accused: criminal penalties. Wrongful conviction for a crime based on a false accusation can lead to imprisonment and fines. Reputational damage. Even if found not guilty, the stigma of an accusation can be long-lasting and harm personal and professional relationships. Legal action. The falsely accused person can pursue legal action against the accuser, such as a lawsuit for malicious prosecution or defamation. Consequences for the false accuser. Criminal charges. Intentionally filing a false police report is a crime in itself and can lead to criminal charges. Lying under oath is the crime of perjury. Civil liability. An accuser who intentionally lies and harms another person can be sued for defamation, false imprisonment, or malicious prosecution. Reputational harm. When the truth is revealed, a false accuser can face their own public repercussions and loss of credibility. Action, in the sense of a judicial proceeding, includes recoupment, counterclaim, set-off, suit in equity, and any other proceedings in which rights are determined. UCC 12011. Action, conduct, behavior, something done, the condition of acting, an act or series of acts. Practice, the legal and formal demand of one's right from another person or party made and insisted on in a court of justice. Pursuit of right in court, without regard to form of procedure. Form of suit given by law for recovery of that which is one's due. Judicial means of enforcing a right. Judicial remedy for the enforcement or protection of a right. An ordinary proceeding in a court of justice by which one party prosecutes another for the enforcement or protection of a right, the redress or prevention of a wrong, or the punishment of a public offense. Black's Fourth. In law, an action refers to a formal judicial proceeding initiated by one party to enforce a right, address a wrong, or settle a dispute. It is a broad term that encompasses both civil and criminal cases, though the specific process varies considerably depending on the legal context. Core components of a legal action. All legal actions involve the following fundamental elements. Parties. There must be a party initiating the proceeding, e.g., the plaintiff in a civil case or the prosecution in a criminal case, and a party against whom the action is brought, the defendant. Cause of action. The specific legal claim, such as for negligence, breach of contract, or medical malpractice, that justifies the right to sue. It is based on a set of facts or a specific legal theory that, if proven, entitles the plaintiff to a legal remedy. Initiation. A case is formally started or commenced by filing a complaint or petition with the appropriate court. Judicial forum. The proceeding takes place in a court of law or before an administrative body. Objective. The goal is to obtain a legal remedy, which could be monetary compensation, in order to stop certain behavior, or a judgment that resolves the dispute. Civil versus criminal action. The type of legal action depends on the nature of the alleged offense and the goal of the proceedings. Stages of a civil action. Most legal actions, particularly civil lawsuits, follow a predictable path through the court system. Pleadings. The plaintiff files a complaint outlining the cause of action. The defendant files an answer responding to the claims and may include affirmative defenses or counterclaims. Discovery. Both parties exchange information, such as documents, witness lists, and evidence. This is to prevent surprises at trial and prepare each side's case. Motions. Either party can file pre-trial motions to ask the court to rule on specific legal issues or dismiss the case entirely. A common example is a motion for summary judgment, which is used to ask the court to rule in a party's favor without a trial. Trial. If a case isn't settled or resolved by a motion, it goes to trial. The parties present their arguments, evidence, and witnesses to a judge or jury. Verdict and judgment. The judge or jury delivers a verdict, which is the final decision on the outcome of the case. The court then issues a judgment that specifies the legal remedy. Appeal. A party that is unhappy with the verdict can ask a higher court to review the decision. The giving or pronouncing a judgment or decree in a cause. Also, the judgment given, or the entry of a decree by a court in respect to the parties in a case. It implies a hearing by a court, after notice, of legal evidence on the factual issue involved, the equivalent of a determination, and contemplates that the claims of Allege, the parties thereto, have been considered and set at rest. The term is principal, used in bankruptcy proceedings, the adjudication being the order which declares the debtor to be bankrupt, Black's Fourth. Adjudication is the legal process of resolving a dispute or deciding a case through a formal, authoritative judgment. It is the foundation of a judicial or administrative system, where a neutral third party evaluates evidence and arguments to render a binding decision. Core components of adjudication. Resolution of a dispute. Adjudication settles conflicts between two or more parties by determining the legal rights and wrongs of their actions. Neutral third party. The decision is made by an impartial authority, such as a judge, jury, or administrative law judge, who is independent of the disputing parties. Binding decision. The outcome, called a judgment or verdict, is final and enforceable by law. It carries legal weight that the parties are obligated to respect. Due process. The process is governed by procedural rules that ensure fairness for all parties involved. This includes the right to present evidence, cross-examine witnesses, and be heard. Key contexts of adjudication. 1. Court-based adjudication. This is the most formal type of adjudication, involving the traditional court system. Civil cases involves disputes between individuals or organizations, such as breach of contract, property disputes, or personal injury claims. Criminal cases. A court determines if a defendant is guilty or innocent of committing a crime. Juvenile cases. A specialized form of court-based adjudication for minors. The focus is often on rehabilitation rather than punishment, and the final decision is a disposition, not a conviction. 1. Administrative adjudication. This process is conducted by government agencies to resolve issues related to their specific regulations and programs. Purpose: resolves disputes between an agency and a private party or between two private parties over a government program. Examples: deciding an application for government benefits, a business license, or imposing a penalty for violating a regulation. Formal versus informal. Can involve formal hearings presided over by an administrative law judge or more informal procedures, depending on the statute. 1. Alternative dispute. Resolution, ADR. Adjudication can also include less formal methods like arbitration, where a third party makes a binding decision, and mediation, where a neutral party helps facilitate a settlement. Adjudication process. Breakdown. Court-based. The court-based adjudication process typically involves 3 stages. 1. Pre-trial stage. This includes filing the initial complaint or charges, the discovery phase where evidence is exchanged, and the filing of motions. 1. Trial stage. This stage involves jury selection, opening statements, the presentation and cross-examination of evidence, closing arguments, and the deliberation and verdict by the judge or jury. The required standard of proof varies depending on whether it is a criminal or civil case. 1. Post-trial stage. Following a verdict, this stage includes the judgment or sentencing, the possibility of appeals to a higher court, and enforcement of the judgment. A written or printed declaration or statement of facts made voluntarily and confirmed by the oath or affirmation of the party making it, taken before an officer with authority to administer such oath. Blacks first. An affidavit is a written sworn statement of facts voluntarily made by a person, known as the affiant, and confirmed under oath or affirmation before an authorized officer, such as a notary public. It functions as sworn testimony outside of court, carrying significant legal weight and making the affiant legally accountable for the truthfulness of the information. Legal breakdown of an affidavit. To be legally valid, an affidavit must adhere to a specific structure and include several key elements. Commencement identifies the affiant by name and location and references the relevant legal jurisdiction. Body contains the factual statements, organized into clear and concise numbered paragraphs. The statements must be based on the affiant's first-hand knowledge, not opinion or hearsay. Jurat, a clause at the end where the notary public or other officer certifies that the affiant swore or affirmed the statement in their presence. Signature, the affiant must sign and date the document in the presence of the certifying officer. Notarization, the certifying officer verifies the affiant's identity and applies their official seal, which authenticates the document. Legal implications. Penalty for perjury. Signing a false statement in an affidavit is a criminal offense known as perjury and can lead to fines or imprisonment. Voluntary statement. The affiant must create the statement voluntarily and without any coercion. A court may deem an affidavit signed under duress invalid. Competence. The affiant must be of sound mind and capable of understanding the document's contents and the consequences of signing it. Common uses for an affidavit. Affidavits are used in various legal proceedings and administrative matters when presenting sworn testimony is necessary without a personal court appearance. Common applications include family law cases. Financial affidavits, for example, are used in divorce cases to detail assets, debts, and income. Estate and probate matters. An affidavit of heirship can help transfer a deceased person's property to their beneficiaries. Immigration. An affidavit of support may be used to promise financial assistance to an immigrant. Business transactions. They can be used to verify facts, such as a contractor confirming tax withholdings. Court motions. Affidavits are often filed to provide a factual basis for legal motions and can serve as evidence if a witness is unavailable. Affidavit versus sworn statement. While all affidavits are sworn statements, not all sworn statements are affidavits. The primary distinction is the level of formality and authentication. Agreement means the bargain of the parties in fact is found in their language or by implication from other circumstances, including course of dealing or usage of trade or course of performance as provided in this code. Whether an agreement has legal consequences are determined by the provisions of this code, if applicable. Otherwise, by the law of contracts. Section 1103, UCC 12013. In law, an agreement is a mutual understanding or arrangement between two or more parties. While all legally binding contracts are agreements, not all agreements are contracts. The key legal distinction is enforceability, which depends on whether the agreement contains certain essential elements. A contract is a specific type of agreement that the law recognizes and will enforce. Agreement versus contract. What's the difference? An agreement is a broad term for any understanding between two or more parties, and it is usually informal. For example, agreeing to have lunch with a friend is an agreement, but it lacks legal consequences if one party cancels. A contract is a formal, legally binding agreement that creates mutual obligations enforceable by law. It requires specific elements to be valid, and if one party breaches the contract, the other has legal recourse, such as suing for damages. Essential elements of a legally binding agreement, a contract. For an agreement to be legally enforceable as a contract, it must contain all of the following elements. Offer and acceptance, mutual assent. One party, the offerer, must make a clear, definite offer to another party, the offeree. The offeree must then accept the terms of that offer without any changes. A conditional acceptance or a change to the terms is considered a counteroffer, which terminates the original offer. Consideration. Each party must exchange something of value. This can be money, goods, services, or a promise to do or not do something. Consideration is what differentiates a legally binding contract from a one-sided gift. The value exchange does not need to be equal, but it must have legal sufficiency. Legal capacity. The parties entering into the agreement must be legally competent to do so. This means they must be of legal age, typically 18 or older, of sound mind, and not impaired by drugs or alcohol to the extent that they cannot understand the agreement. Legality of purpose. The contract's purpose and subject matter must be legal and not violate any laws or public policy. A court will not enforce a contract that involves illegal activities. Intention to create legal relations. The parties must intend for the agreement to have legal consequences. This intention is generally presumed in commercial agreements, but is often lacking in social or domestic arrangements. Common types of agreements. Not all agreements require the strict legal framework of a contract. The enforceability of an agreement often depends on its type and context. Letters of intent, LOI, and memoranda of understanding, MOU. These are written documents that outline a mutual understanding or future plans. They are generally not legally binding unless they contain specific contractual language. Informal agreements, handshake deals, and verbal agreements, while potentially enforceable, are difficult to prove in court. They rely more on trust and goodwill than legal backing. To state, recite, assert, or charge. To make an allegation. To affirm, assert, or declare. Black's Fourth. In law, to allege means to assert a fact or claim without having yet proven it to be true. An allegation is the formal, unproven statement made by a party in a legal proceeding, such as a plaintiff or prosecutor, to establish the basis for their case. The truth of an allegation must be proven later, typically through the presentation of evidence during a trial. Key characteristics of an allegation. Unproven claim. An allegation is not a proven fact. It is a statement that a party believes to be true and intends to prove in court. For example, a plaintiff in a lawsuit might allege that the defendant was negligent, but this is simply a claim until they provide evidence to back it up. Serves as the foundation of a case. Allegations form the building blocks of a legal complaint or indictment. They provide the court and the opposing party with notice of the specific claims being made. Formal legal assertion. An allegation is a formal statement made in a legal filing, distinguishing it from an informal claim or accusation. Used by all parties. While plaintiffs and prosecutors make initial allegations, defendants can also make their own as part of an affirmative defense or counterclaim. Allegations in different areas of law. Criminal law. In a criminal case, the prosecution files an indictment or complaint that alleges a defendant committed a crime. This is an accusation that must be proven beyond a reasonable doubt to secure a conviction. The use of allegedly by media and others is a way to respect the defendant's presumption of innocence until the case is proven. Civil law. In a civil lawsuit, such as for a personal injury or breach of contract, the plaintiff files a complaint that alleges the defendant caused them harm. The plaintiff then has the burden of proving these allegations, often by a preponderance of the evidence, which means showing it is more likely than not that the claims are true. Allegation versus proof. The burden of proof. The distinction between an allegation and a proven fact is governed by the burden of proof, which is the legal standard that determines which party is responsible for proving a claim. Who has the burden? Generally, the party making the allegation, the plaintiff or prosecutor, has the burden to prove it. Criminal cases. In criminal court, the prosecution must prove its allegations against the defendant beyond a reasonable doubt, the highest standard of proof. Civil cases. In civil court, the plaintiff typically must prove their allegations by a preponderance of the evidence, a lower standard that requires proving that a claim is more likely true than not. stated, recited, claimed, asserted, charged. Black's fourth. Appearance. Bond. Type of bail bond required to ensure presence of defendant in a criminal case. As a secured party creditor, you can request an appearance bond without fees and charges from the judge or prosecutor. This is the most valuable use of your one free call and is the recommended first-order business on being booked into jail. You can ask for the bond at your arraignment. In law, alleged means something has been claimed or asserted to be true, but has not yet been proven in a court of law. The assertion, called an allegation, is a formal statement of fact that a party intends to prove through evidence during a trial. The word acts as a legal qualifier to respect the principle of innocent until proven guilty. The purpose of an allegation. Foundation of a case. An allegation forms the basis for a legal case. In a civil lawsuit, a plaintiff outlines their allegations in a complaint, while in a criminal case, the prosecution details its allegations in an indictment. Defamation protection. News organizations and public figures use the term alleged to avoid libel or defamation lawsuits when reporting on unproven claims. By using the qualifier, they are stating that they are reporting accusations, not verified facts. Doubt and suspicion. When used outside of formal legal proceedings, alleged can also suggest that a claim is doubtful or has not been confirmed. Alleged in different legal contexts, criminal law accused, not convicted. An individual is an alleged criminal or alleged murderer until a jury or judge finds them guilty beyond a reasonable doubt. Example: a news report might state, "The alleged thief was caught on camera," because until a verdict is reached, the individual is legally presumed innocent. Once convicted, they can be accurately described as the convicted thief. Civil law plaintiffs claim. In a civil lawsuit, such as for personal injury, the plaintiff makes allegations about the defendant's actions. For example, a plaintiff might allege that a driver was negligent. Burden of proof. The plaintiff must then provide evidence to prove their allegations are true, typically by a preponderance of the evidence, meaning it is more likely than not that their claims are accurate.